So, what are some pros and cons of E-B petitions? Hi, folks. Welcome to U.S. Immigration Simplified. I'm immigration and business attorney Ronald Lee. Employment-based immigration petitions offer a pathway to permanent residency in the U.S. for skilled workers, professionals, and investors. However, the process comes with benefits and challenges depending on the specific category. Starting off with pros. One is permanent residency. Successful E-B petitions lead to a green card, allowing the beneficiary to live and work permanently in the U.S. Two, employment flexibility. After obtaining a green card, beneficiaries are not tied to the sponsoring employer and can seek other job opportunities. Three, family inclusion. Spouses and children under 21 can obtain green cards as derivatives of the principal applicant. Four, path to citizenship. Green card holders can apply for U.S. citizenship after 5 years of permanent residency. There are multiple categories, which can accommodate a full range of skill levels and job types. EB1 for extraordinary ability, outstanding professors, researchers, and multinational managers. EB2, advanced degree holders or exceptional ability professionals. EB3, skilled workers, professionals, and unskilled workers. EB4, special immigrant, including religious workers. EB5, investors creating jobs in the U.S. 6 is dual intent. Unlike some temporary work visas, E-B petitions allow dual intent, meaning applicants can pursue permanent residency without jeopardizing their current non-immigrant status. 7, high visa numbers for E-B categories. 140,000 visas are allocated annually for E-B categories, making it a viable option for many skilled workers. Now on to cons. 1 is a lengthy processing time. Processing times can be lengthy, especially for categories with a backlog, for example, EB2 and EB3 for certain countries like India and China. 2 is costs. The process involves significant expenses, including filing fees for Form I-140, I-45, etc., attorney fees, and other associated costs like medical exams and translations. 3, complex requirements. Each EB category has strict criteria. EB1 requires evidence of extraordinary ability or international achievement. EB2 often requires a labor certification, known as PERM, unless a national interest waiver is granted. EB3 requires a valid job offer and labor certification. 4, employer dependency. Many EB categories require employer sponsorship, tying the applicant's immigration status to the employer's willingness and ability to support the process. 5, visa backlogs. Certain categories and nationalities like India and China face extensive waiting periods due to visa quotas. Uncertain outcomes. Applications can be denied due to insufficient evidence of eligibility, errors in filing or documentation, employer inability to meet financial requirement. 7, geographic restrictions for EB5. EB5 investors must commit funds to specific regional centers or targeted employment areas, which can limit investment flexibility. 8, job offer requirement. Most categories except EB1A and EB2 NIW require a job offer, which can be a barrier for applicants who do not have one. And 9, risk of PERM denial. EB2 and EB3 often require a labor certification, which can be denied if the employer fails to prove no qualified U.S. workers are available for the position. If you are interested in applying for an E-B petition, feel free to text me at 312-804-1386 or email me at ronald@rdllawgroup.com.